Sir, obviously you're still under oath. You'll be back tomorrow morning, and we'll continue with cross-examination. Okay, sir?
Yes, Your Honor.
All right, thank you so much. You're free to go. Counsel, you need a seat for a second. Just get one thing. I'll be right back. This is not a formal charge conference, but the attorneys and the court have gone back and forth as it relates to the jury charge, especially when it was previously scheduled for trial in September. We've gone through a couple drafts. We are now embarking on draft number 4. As mentioned a little bit earlier, this was, the court had requested for the input from both counsel to provide any other edits and or any additions or deletions that they may have to the charge. I did receive something from the state. The defense then added their thoughts as to the charge. I have that. What I'm asking for now, if the prosecutor, if you've had time to take a look at where we are with the charge, and if you have any other concerns, if not, I would put this in a draft form number 4, send it back to you in this version. I have some minor things that I would take a look at myself, but I just wanted to hear from the state first.
Judge, I looked at it previously, but I printed it out over lunch.
Okay.
We was trying to identify the areas. We would just have to, since on page 9, add Michael Abraham in the expert portion.
Let's go back. So we have to, on page 7, I think we need to add the stipulation
Yes.
from Petrazillo. We also had a stipulation with Paul resigning from the trust.
Yes.
So we need to put that in there, and also the stipulation regarding certain business records, correct?
Yeah, those are the two, correct? I believe every.
Right, the Petrazillo and the trust are the same one.
Yeah, that's what.
Okay, as long as we're good with that there's nothing else there.
I did advise the state in the email. There is a third stipulation that, or something maybe potentially we'll discuss with them, and then we'll revisit it.
Okay, we can always add to it. All right, so, and I know you probably can't see it from there. I know I wouldn't be able to see it if I were you. But I have, I believe, the stipulation that both sides have agreed to as it relates to Petrazillo. So you guys can take a look at it if you want. But do I have the other stipulation? Not the one that may come up, but the other one. Dealing with...
The business records.
Yeah, the business records.
No, I think that, I think the way it was discussed previously, Mr. Murray drafted it, we've looked at it, we certainly agreed with it. I think we had discussed previously that it might not need to formally be read, correct? I mean, because I don't know that every business record came up. So maybe a summary of that, because I think some of the things that are listed never actually made its way to the courtroom, so they'd be out of context.
Look, I mean, the way... I'm sorry, Mr. Murray, you talk first, and then I'll tell you what I was going to say.
No, I'm sorry, Judge, but I was just going to say, like, it was really a stipulation to the admissibility of evidence between the parties rather than a stipulation about facts that were before the jury. So my impression of that would be it is not something that needs to be within the charge itself. Mr. Decker's right. Many of those records were not even referenced over the course of the trial. It was just about them being trustworthy in the sense of being kept in the regular course of business.
Okay. Well, if we want to leave it alone, I can leave it alone. Or what we could do is after the state moves in its evidence, if at that point now we're looking at the evidence all at once. If there's something there, then at that point, the defense can propose something to me, and if the state has no issue with it, then I can put it right in that spot. Is that fair?
Yeah, that's fine.
All right, so let's leave it there for now, and then we'll go back to it. All right, Mr. Decker, I didn't mean to stop you. I apologize. Let's go to 9 again.
Oh, 9 would just be adding Mr. Abraham, I believe. Everything I think the defense has
All right,
proposed.
so we heard from, and we need to put in for each one, I think, we just have to confirm, I have to look through my notes exactly the way that each expert, how they were titled. Yeah, I was going to say, I didn't remember, I don't have any notes on Lindsay Sani.
Lindsay Sani, Catherine Korecki, and there was one more, Erica Hunger.
Okay, that's exactly the notes that I had, so good, we're on the same page with that. Obviously, we'll add Judith Link, and then if, again, assuming that if the defense has an expert, if they decide to call, then we would add that also. Okay, so we'll make that change. Page 10, I'm going to take the underline out. There's no reason for that to be there. You all look at that. I'm not even sure why it was underlined. But
I just think in one of the earlier drafts, things that were added were underlined. That might be why.
that may be why. Okay, all right, fair. So we're going to take that out because I don't want there to be any issue there. Page 11. So we're agreeing on the highlight. Top of page 11. In this case, the 2 paragraphs there, they're really 2 lines, but 2 sentences.
Yeah, Judge, I think we're in agreement on that. I mean, at least.
Yeah, and I was going to take out 8 and 9, line 8 and 9, because it doesn't exist. Do we agree? Defense?
Yes, we agree.
Okay. So 8 and 9 are out. So then lines 1 through 4, we'll just take the highlight out of it. Page 12, I'm just going to take out the underline under lines 1 through 9. So I don't think we need that anymore. Mr. Decker or Ms. Wallace, I apologize. Any issues with the line 21? Just the little addition there? I don't think so, but just...
No, there's no issue, Judge.
Okay, so we're going to add that and take the highlight out of it. 22, I think both sides are in agreement with, that it's 3 phone calls. Okay, we have everyone's good with the limiting instruction on page 13 into 14. Okay. We're all good with the witness pretrial prep because it's in highlight, and there's I don't see anything from the defense, so we'll add in, it's just the prosecutor's names and the 2 leads. We'll clean it up to make it look a little bit better, but.
Right, I mean, I don't know what the cross-examination of any defense witnesses will be, but obviously it applies to both sides. We'll add it in at the appropriate time.
That makes sense, okay. But we'll just have it read, you have heard testimony about Assistant Prosecutor Chris Decker. It will take out the insert name, all that stuff. It'll just be the names. All right. We'll talk about line 20 a little bit more later. Let's just leave that for where it is. but we know that you want it, and we have that charge. So we have both sides of it. So we'll talk about that one. All right, page 15, the lesser included. Ms. Mastalone, I know, and Mr. Murray, I know we've discussed this in the past. I just want to confirm with you, as of now, the only lesser included that we're talking about is the arson to an aggravated arson. There's no other requests for any other lesser included. Is that correct?
As of right now, no, Judge.
Okay. That's something that, as we get into next week, that I'm going to ask for you to make sure that you've spoken to your client about that, and I'm going to ask him that question on the record to make sure that he's comfortable with that. As long as he's good, also, then we'll be good on that. But again, that's, you let me know on that. As I mentioned, and also to say it in front of Mr. Caneiro. Mr. Caneiro, you've read this, the jury instructions, right? Okay. All right. So just for the record purposes, the way that the court's going to read the murder charges, counts 1 through 4, it will be, I'm going to read it once for all 4 of the alleged victims here, and I will go down and I will go through count 1, count 2, count 3, and count 4, so it's very clear to the jurors. What I will do when it comes to this, which is not normally what we do, is when it comes to counts 1 through 4, because we have the issue of the secondary questions, if the jurors were to find Mr. Caneiro guilty of any of the 4 counts of murder, there's subsequent questions that need to be answered. So I'm going to show them the verdict sheet at that point just to talk about this area, and then I'm going to take the verdict sheet away from them so that they don't focus on the verdict sheet instead of focus on what I'm saying. So just so, does anyone have any issue with me doing it that way?
No, Judge.
No? Okay, good. I don't want them getting ahead of us. Other than that, there's the minor correction on page 23 that will change felony murder charge, which only deals with Jesse and Sophia. It'll be read once. And again, we will take out the underlines. So there's no emphasis anywhere in this. Okay, on page 27, we will take the highlight off because both sides are good with the language. So thank you both for agreeing on that. And the aggravated arson, again, we'll take all the underlying parts out of it. And then we'll go into the lesser included of arson. Again, we'll take the underline out of it. As it relates to the possession of a weapon for unlawful purpose in count 9, which includes all 4 victims, I understand the state's position, obviously, as it relates to Keith and Jennifer, because they both suffered gunshot injuries. I want to hear from the medical examiner first before I make the final determination, but I understand the theory as it relates to Sophia, but I just want to hear that before I make the final decision on that. Okay. So let's just leave that charge alone. Because 35, I'll have to fix that depending on where we go with it. Unlawful possession of a weapon, just dealing with having a permit to carry the same. Talked about in this case, defendant legally carrying or legally having guns in his home. Is the state alleging that he does not have a permit as it relates to the gun used in this case? The item number 15?
Judge, I think that's why the language was changed to permit to carry as opposed to possess. Because he has permits, not permits to carry.
Okay. All right, well, I'll wait to hear as to count 10 because as it relates to the elements of that charge. Count 11 deals with the knife, the alleged knife in this, so that's fine. We'll take out any underlines on that. 12 deals with unlawful possession of a weapon, which again deals with the knife. Again, we'll take the underlines out of that. What we're going to do is let me say this. As it relates to count 11, possession of a weapon for unlawful purpose, the exhibit number is what number for item 15? Just remind me, 306? Is that what it was? I just want to add that into the
193, Judge.
193, I'm sorry.
Okay.
So it's exhibit, that's what you're alleging in count 11? 193?
No, this is the knife. No.
Not 11, I'm sorry. Count 9.
Yes.
Okay. 193. All right. Count 10, I'll just put it in here for now. Again, it'll be addressed later, 193. As it relates to count 11, what exhibit are you referring to for count 11? Do you know yet?
I do know. I just don't know that. S313.
I'm sorry, I didn't hear you.
S313, Judge?
313? Okay. All right, so that applies to 11 and 12?
Yes, Judge. I believe so.
Okay. Okay. This just goes to show that I missed page 43 where you're alleging 316.
Yeah, I know. That's why I walked back over there. I wrote 316 in the charge, but it's 313 on the list.
313?
13.
All right, so I'll change
Our list change after I tweak this, maybe.
All right, so it's 313. We'll fix that. 313. And when you say and or another knife, you're just not saying which one that is?
Correct.
Okay. All right. So no issues with the additions on page 45.
I didn't see any issues with that, Judge.
Yeah, Ms. Vassalone, I'm assuming that if she disagreed, you would have put that in blue next to, on page 45, right?
Correct, Judge. I think that's been in there for a while.
Okay.
I'm
Just,
not sure. Yeah, I think that's been in there.
okay. All right. 14. Just take out the underline on page 48. Okay. I normally don't add anything about sidebar. What's the state's position as it relates to that? I'm not really. I mean, obviously they know that I have to make decisions outside their presence as it relates to certain issues, but go ahead, I'll hear it from you.
I've just never seen it before. I don't know that it's necessary. I just get a little nervous to add something that is not contemplated in the model.
Yeah, I'll look at it again, but Ms. Vassalone, what I'll do is I'll allow you to put when we do our charge later, allow you to put your position on the record as it relates to this, if this is what you're looking for. Some of this is what you alleged in the past, which I've disagreed with you on, but we'll put that on the record so that you have the opportunity to protect the record as you see fit. All right, so what we'll do is we'll change this. I'll make it draft 4. What we'll do is we're going to mark the one that we have from you all with just your edits. We'll make that an exhibit, and then we'll make the new draft number 4 an exhibit so that we have covered every version that we have, because we have all the other versions in the back. All right, anything else that we need to discuss? And we'll have this to you by the end of the day tomorrow. You'll have it so that you have time to look at it. And then we'll figure out the day we're going to do the charge conference when we get a little bit closer. Anything else the state needs to discuss?
No, Judge.
Defense?
Judge, there is one thing I just wanted to put this in the record / discuss, but could we do it at sidebar?
Sure.
On the record?
Yeah. Hey, we'll start back up tomorrow morning at my copy? Put everything that was said, obviously you guys know what to do if you want. But we have to preserve